Patriot Smoothie here at the end of a very long day 21 for the trial of Tamara, Lich, and Chris Barber. Can you believe it? 21 days already. We are running 5 days longer than this trial was originally scheduled to last. And that raises some issues in the long term in the perception of the administration of justice and the justice system here in Canada. That's a fair question to have, especially when we have what could be considered potentially politically motivated charges from a very political demonstration against the current government of Canada, the Justin Trudeau Liberals. So that's an interesting perspective to maintain. However, I want to mention that the presiding justice, Judge Heather Perkins McVeigh, has been phenomenal in running this trial fairly, giving every party the fullest opportunity to have a fair shot at a good case, to present their evidence in the fairest way possible, sticking to the facts, making sure hearsay is not admitted as evidence, and exercising what she has called repeatedly her gatekeeping function, what I see after 21 days very, very well. And it's a testament to the way that the justice system is supposed to work in how she's conducting herself in this courtroom. In my opinion, that's truly how I feel about it. She's doing a phenomenal job. So today we had the two requests that were made by the defense yesterday, as I understand it, I believe after the court ended, regarding the revelation that came out that Officer Nicole Bach of the OPS had lost much of her phone's content shortly after convoy, including text messages, including potentially emails and whatever else may have been on her work police phone, because of a IT upgrade. So the defense asked for two things. They asked for the instructions that Officer Bach was given in regards to doing that technological upgrade, and she also asked for communication. They also asked in general for communication to the PLT officers regarding disclosure, and they received probably, I believe, around 12 noon today, around 5 emails, 5 heavily redacted emails between PLT officers, Ottawa police detectives, and the Crown. Now, in those are heavily redacted documents. At one point, the judge held them up, and it was just a black page with a white margin around it. And she said, "What is this?" So the defense was basically saying that they wanted Your Honor to see how redacted it was and potentially look at the amount of material that's actually missing. So in those documents, the Crown claims that OPS Legal, the Ottawa Police Service's legal department, is claiming solicitor-client privileges, including in some of these emails, the subject matter of most of these emails saying PLT disclosure. These emails, some of them exclusively between, I believe, OPS PLT Sergeant Fong Lee and OPS Officer Bach and other PLT officers. I believe there's an email from OPS Sergeant Fong Lee to all the OPS PLT officers. So a lot of questions of how that quite elicits solicitor-client privilege, but the OPS Legal nonetheless claiming that. And for the rest of the redacted sections, the Crown is claiming it's irrelevant. So in either case, the defense will have to bring a couple of applications here to unredact this document, including one to pierce the solicitor-client privilege, and a third-party request for those emails to unredact them, because the Crown is claiming that portion of the documents are irrelevant. So they're going to have to make a third-party request on that portion, and then another portion for what the OPS is claiming is solicitor-client privilege, including in emails, again, which we understand to be currently between exclusively police officers. No solicitor or attorney involved in those to our knowledge at this time. That's what we're hearing in court. And there's also the defense, basically the Crown said, the judge asked if there was anything else that could be done today, and both the defense parties, including Magus for Barber and I believe Magus for Barber and Granger for Lich, rising to say that they didn't want to take this any further because they don't want to go down a line of questioning and come upon something that might dramatically change based on the disclosure they received. They were saying that they were ready to make oral application today for these numerous applications to unredact these 5 emails, but the judge basically saying, no, I want that in writing, and then so that, for example, the Ottawa Police can be served that the applications that they need on their behalf to start moving this ahead. So again, it looks like we're going to get into more legal arguments and less hearing the evidence. We're going to be taking up more time, more court time on legal arguments instead of actually having this case move forward. And it's just the way it is. As the judge said, as even Magus said in the scrum outside, a trial is a moving thing with moving parts that develop as we go along. So that's just to be expected to some degree. But I have to admit that at some point, the perception of what's happening may affect how it's perceived by everybody at large, especially again when we have what could be considered a quite political case here. That's the same in many other cases, like in also the Coots 4 situation, where we have 4 men in jail for over 600 days And a lot of people have a lot of questions about the situations there that are keeping these men in jail. So we have a lot of questions right now. It's fair to have questions. You're allowed to have questions in a democracy about how your system is operating and about its integrity. And we have questions about that for sure, watching these proceedings unfold across the country. But again, a testament to the justice system is Justice Heather Perkins McVeigh and how she's running this trial. Phenomenally good. And as well, as you might have heard in the other update with Jason Levine, how he was describing the judge in that case today, October 20th, allowing arguments on this, the envelope to be heard. So these are positive developments and things that we need to keep in perspective when we're evaluating the trial as a whole and the system of justice in Canada. So just remember, it's frustrating, but there is still some hope there. There's still some hope there, and we need to focus on that hope and focus our energy on moving that hope along. The scheduling is totally uncertain. There's possibly Thursday and Friday next week. I'll find out at 4:30 for sure, and I'll report back to you, and possibly also Wednesday next week. And again, we're talking about October 31st and the first few days in November. Once again, those are possibly dates. So we've gone back and forth on those particular dates several times now. So how that's going to move along, I don't know. I'm not comfortable reporting the schedule anymore because it seems every time I do, it changes. So I will get back to you as soon as I hear something concrete in court. Also, I wanted to bring up the February 13th counter-protest, the so-called Battle of Billings Bridge. Now, we heard testimony yesterday from Officer Nicole Bach from the Ottawa Police that Barber said in a text message to her that he was, or she described him as, quote, panicked. And now you also have to consider that Barber was bringing her information about a situation he perceived to be dangerous. So I think that shows how responsible he was. Now we should look at the Billings Bridge protest, the so-called Battle of Billings Bridge, where several dozen convoy protesters were held against their will for several hours, I believe 8+ hours, and that's forcible confinement. Now in Canada, that's illegal. Can you imagine what would have happened if Chris Barber or Tamara Lich had done anything like that, where they encircled a group of people, and whether they gave them conditions on what they had to do to leave or not? Totally unlawful. Can you imagine if Chris Barber or Tamara Lich did anything or instigated anything like that happening, where we have an actual example of people being encircled, surrounded, and held against their will and intimidated by a large group of people, like not just by the sound of horns or the smell of odors or smell of idling trucks, but by actual aggressive, agitated people surrounding, banging on your car, ripping things off your car, banging on it, and surrounding you for hours in front of police. Can you imagine if Chris or Tamara did that? I imagine this trial would be dramatically shorter because there would be a lot more material, much more implicative material for the Crown to work with. That's just something to think about. Now, one more thing, the voir dire, and I know I say that wrong. I know I say that wrong. A lot of people don't like that. The voir dire that we entered in briefly yesterday concerning comments that Chris Barber may have made about the Prime Minister. The Crown maintains in that voir dire that it goes towards count 5 of the offense, blocking highways to intimidate members of government or agents thereof, up to and including the Prime Minister. And basically what Barber said was that the convoy wasn't going away, and it's not going away until Justin Trudeau acknowledged it and removed the mandates. Now, that was entered into a voir dire just because there's a lot of questions about political opinions, for example. Political opinions, the judge even remarking at one point, she's not much interested on what Barber thought of one official, one politician or another. But that's where we found ourselves, and we didn't get a resolution to that again because the defense maintained their arguments for that voir dire to their cross-examination. We only briefly started that yesterday. Again, all these other disclosure issues that seem to be an ongoing theme throughout this trial. Until next time, I'll see you Monday. I'm Patriot Smoothie in Ottawa.